Mooting has been around in law schools for a very long time, and it's a crucial part of every law undergraduate's training. In essence, it's a fictitious appeal to one of the higher appeal courts, like the Court of Appeal or the Supreme Court, on a point of law. It could be really anything to do with criminal law or any aspect of civil law. Typically moots cover things like criminal law, law of tort, law of contract. But basically, it's where there's a point of law is at stake and is up for legal debate, really. And the idea is the appeal is brought to overturn a judgment in a civil case of, say, the High Court, the County Court, or in a criminal case, to overturn a conviction. And the students basically have to argue various aspects of their case, argue this point of law before a senior appeal court judge, either in the Court of Appeal or the Supreme Court. What makes a good moot really is where the point of law at stake, up for argument, is very equivocal. And it's open to perhaps a lot of debate, a lot of interpretation. Different cases say perhaps slightly different things or go different ways when considering the point in question. There's perhaps a conflict of authority, a conflict of case law authority in this country or with other common law jurisdictions like Australia or Canada or New Zealand, or where the point of law really is equivocal and it's open to real argument over what the law actually is.
For the sake of brevity, may I direct your Lordship straight to the quotes on page 107?
There's numerous benefits for students with mooting. To list them really, many transferable skills are acquired by students who undergo mooting and moot training. Research skills, students have to sort of dig out, ferret out all the relevant case law, look at academic books and articles, where the point of law is equivocal, to try and build up arguments to support their submissions, their case, as to what they're suggesting to the court the law should be. So research skills, putting together a good bundle of legal documentation for the judge, drafting a skeleton argument, a sort of summary, a synopsis of their basic legal submissions which they are making and hoping to persuade the court to follow. Drafting that skeleton argument is a skill in its own right.
With a final reference to this case, may I refer your Lordship to the judgment of Lord Justice Bolcombe on page 335.
It's a form of public speaking, good eye contact with the judge, a good pace of delivery, clear, articulate delivery. All these are good oral communication skills which are enhanced very much when one undergoes moot training and mooting.